Law for Life, the podcast, with Franklin Solicitors.
Hello, welcome to another episode of Law for Life, the Franklin's podcast. Today, it's great to be joined in the studio by Sara Marshall from Franklin's. Hello, Sara.
Hello, Chris.
Now, the reason we've got you back in is because we're reopening the can of worms that is the Employment Rights Act. And I know we've done a couple of podcasts about this before. While it was a bill, things were changing literally on a weekly basis. And now, hopefully, we know how things are going to be and we can give you an overview of what it means for businesses and we can sort of see how things pan out as it comes into effect. So, in a nutshell, what is the Employment Rights Act?
So the Employment Rights Act is now a law. So from the 18th of December 2025, the bill was made into a law. And the purpose of the law flows back to September 22, when Labour's manifesto was to make work pay. And the idea of it was to enhance workers' rights, keep workers in their jobs, improve productivity, and improve living standards. The bill is coming through over the next 18 months. There's lots of changes. It's a fairly lengthy process, and I would say it's the biggest change to employment law for the last 30 years. So significant changes, and I think it's important to look at bite-sized changes. So there's a few things that we'll have a look at, those which are coming into effect from the 6th of April.
Okay, so it's quite a big change, and it affects anybody that's in business that employs people, basically, because
Yes.
there's a lot of changes here. So what are the main things that are changing with the Employment Rights Act?
Okay, so if we have a look at from the 6th of April, we have a change to collective consultation. So just a reminder of collective consultation. Collective consultation arises when an employer wants to make 20 people or more redundant from one establishment at one time. The law around collective consultation is not changing. However, the penalties for not going through the process are. So employers will be severely hit. So previously, there was such a thing as a protective award, which was 90 days pay if you failed to go through that process. That doubles overnight to 180 days pay.
Wow.
So if we think about 35 people being made redundant and an employer fails to go through that process, that's a hefty bill.
That's 6 months of your wage budget,
Correct.
basically just gone because you didn't follow the right process. So this is where you're making lots of people redundant at the same time. So it's sort of collective redundancy.
Yes.
So that's one thing that's changing. Is there anything else around this?
So from the 6th of April again, we're looking at statutory sick pay. So statutory sick pay is changing in the qualifying period of employment. So previously you had to have on the fourth consecutive day you would receive statutory sick pay. The first 3 days were non-qualifying days. Now it's a day one right. So immediately from day one you're entitled to statutory sick pay. There is still a cap on that, so it's a weekly cap and depends on someone's salary, of course, but that earnings threshold then becomes removed. So what really changes is that ability for people on a lower income to receive statutory sick pay right from the very beginning. It does not change companies' enhanced payment terms, so companies may already pay enhanced sick pay. That doesn't change. It's just that entitlement to statutory sick pay.
Okay, and that would be within the enhancement. So if you're paying more than the statutory minimum, then that's not going to change. It's just a guarantee of a certain amount that you would get from day one if you are off sick.
Correct.
Yeah. Okay.
Yeah.
So those are two important things that need to be addressed, because otherwise that could come back to bite you. So what would be the consequences if you didn't give someone the statutory sick pay that they're entitled to?
It's not a standalone claim that somebody would take to a tribunal on its own, because you're going to still be employed. But of course, it's a failure to make salary. It will be an unlawful deduction of pay, essentially, if they don't make that payment.
So would they just would the court award them what they should have had, or could there be a fine or penalty?
No, it would be awarding them what they're entitled to.
Okay. And there's also some changes to awards that people can get through employment tribunals.
There is. So again, this flies under the radar at the moment because of the changes in the Employment Rights Act. And this is not a change from the Employment Rights Act, but because there's so much noise around the Employment Rights Act, at the minute we're forgetting that these weekly sums change. So from, again, 6th of April, it changes every year. The amount of pay that you can receive for statutory redundancy and for unfair dismissal, that weekly pay is changing. So previously, it was £719 per week as a cap, and now it's it's going up to £751. So it doesn't automatically again mean everybody's going to receive £751 per week, but it's that cap. So if you receive more than £750 per week, you're capped at that rate.
Okay, that's interesting. And that's already come into effect?
So that will come into effect from the 6th of April. So the changes. So anybody who essentially is made redundant from the 6th of April onwards, then they're going to receive it on the higher rate.
Wow. Okay. So lots to try and get your head around if you are an employer and you have your staff. What's the best way to make sure that everything has been checked off and that you've got all of your policies and all of your documents and all of your payment structures and everything in order?
It's a regular review, so I think when you do reviews of your contracts and your policies, it's always helpful to do them not annually. It's really helpful to do them every quarter and look at what's changing. If we also look at the other change, which is the amount of compensation that can be paid. So at the moment, the limit will increase for the unfair dismissal. Annual amount is currently £118,223. It changes to £123,453, again on the cap of somebody's annual salary. That is going to change, and I'm going to talk about that in a minute when we look at unfair dismissal. But from the 6th of April until January of next year, that will be the annual rate for somebody to claim unfair dismissal.
Okay, cool. So what are the changes regarding unfair dismissal that are coming in?
Okay, so this is a real hot topic for conversation. One that last year obviously made a big difference because we had a big U-turn. So last year we were looking at a day one right for unfair dismissal. If we look back historically, we used to have 1 year right of unfair dismissal. Then it obviously increased to 2 years. So as it currently stands as we are today, you have to have 2 years length of service, continuity of service to bring a claim for unfair dismissal. That's ordinary unfair dismissal. That's not automatic, which is completely separate. But the what will change come January of next year is it's going to be 6 months. So from January, 6 months unfair dismissal right to make a claim for unfair dismissal. But what would be very difficult would be for an employer to become quite complacent now and think, well, that's happening in January. I can sit back, not worry about anything until January. However, what we've got to look at is people who are employed and start to be employed from the summer of this year, because then they're going to gain that 6 months. And when we then come to January, they've got that unfair continuity of service. So you've got to start being proactive now. Look at people's performance. Don't put somebody on a probationary period for 2 or 3 months and think it's okay, we can sit back, let's see how they get on. You've got to manage them. You've got to be proactive. So look at probationary periods if they're meaningful, because you could decide somebody has a 12-month probationary period, but with the 6 months rule for unfair dismissal, they're still going to have a claim within that time if you dismiss them, despite what that probationary period may say. So it's about being realistic about what the probationary period is, what do they need to achieve in that time, and what do we need to look at with regards to performance. So if you've got underperformers, don't wait, look at them, try and improve them. We talked previously about personal improvement plans, and that's where you try and measure somebody's employment, and they should be smart, they should be there to improve someone's performance. And if we do that now and put that in place, it's going to be helpful when we're looking at if we need to terminate their employment, then we're not going to fall foul of the new limit.
Yeah, it sounds like there's a lot to consider at this stage, and obviously getting some professional help with it is highly advised because there's a lot that can go wrong. So you guys at Franklin's are there to support companies through that process of just making sure that everything is done correctly and that you do have those procedures in place to monitor people's performance and make sure that if you do need to make some changes, that you're covered and you're not going to end up facing unfair dismissal claims and things like that.
Absolutely, because if we also think again about unfair dismissal, we have to look at unfair dismissal and redundancy. So although the time limit for 6 months to be able to bring a claim for unfair dismissal is not the same for a statutory redundancy payment, so they used to be in line with each other. 2 years length of service, 2 years you need to make it to have a statutory redundancy payment. Now they're completely separate, so it's 6 months for unfair dismissal, but to receive a statutory redundancy payment you still need that 2 years length of service. So what that in practice means is an employer goes through a redundancy process. You've got people who perhaps have 1 year's length of service, so they have enough to make a claim for unfair dismissal if you make a mistake in that process, but they're not entitled to a statutory redundancy payment. So then you would just give them their notice to terminate their employment. However, generally, redundancy is one of the 5 fair reasons to terminate employment. And if we look at that, the reason most times is genuine, that you're going through a process to reduce your headcount. But it's the process and the procedure that will be where there's claims to be made to an employment tribunal. And if an employer makes a mistake in that process, there may be no entitlement to a statutory redundancy payment, but as soon as they go to an employment tribunal, they may have a claim of unfair dismissal, and then those rights kick in.
And are there any changes to what you can claim in a tribunal as a result of this?
There are. So the tribunals have a real big backlog at the moment of tribunal claims, and if we're looking historically at what that process is to get to an employment tribunal, I would have said 6 months for a preliminary hearing, 12 months for a final hearing. What's happening at the moment is preliminary hearings are not being scheduled until the end of 2027, with final hearings going into 2028, which is why there's a really big backlog. The change that's being made with the Act is only going to make that backlog bigger, and is only going to cause a much harder issue for the employment tribunals. What does that mean in practice? It means that we need to think about alternative dispute resolution. We need to think about mediation. Are there going to be more claims which are settled with settlement agreements and COT3s, which is the process when we go through that tribunal? So I think it's about trying to be more proactive about what's going to help us to settle claims and resolve claims, because the types of claims that we're going to make to an employment tribunal, again from October, that limit's going to change. So from October 2026, we can make a claim, and the time to bring a claim increases to 6 months. So previously, for most types of claims, you had 3 months to bring a claim to an employment tribunal. Now it's going to be 6 months to bring a claim to an employment tribunal. So if we look at that backlog of cases already in an ET, and given people now 6 months to bring a claim to an employment tribunal, all it really means is the end goal is put further and further back. If we also look at what happened at the end of last year, so in December last year, the ACAS early conciliation claims were extended. So the idea of ACAS early conciliation, it's the gateway to an employment tribunal. So before you can get to the tribunal, you have to go through ACAS. And the idea is to try and negotiate and settle any claims you have, and to have that voice between the parties. And again, they were under incredible strain. And it really became a tick box exercise. Have we gone down that process? Yes. Have we got time to negotiate and settle with your employer? Probably not, because of the volume that they had. So they extended that time limit from 6 weeks to 12 weeks, which meant it was supposed to give more time to resolve and settle matters. So if we balance out ACAS early conciliation going from 6 weeks to 12 weeks, employment tribunal claims going from 3 months to 6 months, that just means a bigger headache for the tribunals, because there's going to be more claims. And as an employer, you're just thinking, without thinking about pausing the time with ACAS conciliation, you never know quite when that ET1's going to land on your lap, because that time is just being extended.
Yeah, and it just drags the whole process out. It just means that everybody has that longer period of uncertainty, and for you as a business, you don't know what the outcome is going to be and how much you need to just have put aside in case things don't go your way. So it's going to make things more difficult.
It does make things more difficult. And as I say, I think we're going to be looking at other ways to try and settle things. But again, from the employer's point of view, it's about becoming proactive. So what they really need to do is make sure they have notes of meetings. It's a very easy thing to say. Make sure you minute all meetings you have. Make sure you follow up with correspondence. But it's going to help you later down. So if you're looking at a tribunal case 2-3 years down the line, and you have somebody on HR giving evidence at a tribunal, if they're able to go back and say, here are the notes of the meeting, this is what we said, these were the follow-up emails, these were the follow-up letters, it helps them to explain the story and the journey that they've got to. Whereas if you don't document things, you're not going to remember 2-3 years down the line what's happened, who said what, where and when. So it's about making sure that you follow that process, follow your internal processes and procedures, make sure you go through disciplinaries in the correct way. And if your policy says you have to do a warning, then a written warning, and then dismissal in the absence of gross misconduct, then you must do that, because that's what your policy says. And you've just got to follow that process through.
Yeah, because even if you can remember, no one's going to believe that you remember.
No.
So you've got to have the evidence.
Absolutely.
Okay, is there anything else that we need to touch on as regards the Employment Rights Act?
I think I could sit here all day and tell you about all these changes that are coming up, because it is a really big, significant change to employment law. However, to not bore you, it would be better to look at it in segments, really. So other changes which are coming into place, we've got pregnancy and maternity rights. We have big changes around harassment, which is really quite an in-depth conversation. So my colleague will be talking to you about harassment. Changes around menopause, not so much the law that surrounds it, it's just about the need to have processes in place and protection. At the moment they're voluntary, that will go to compulsory. It triggers at 250 employees, so spoilers there. But all these things we do need to talk about, and we need to have a look at 0 hours contracts, fire and rehire. So there's lots of things which are on the horizon, but it's important that we don't run away with ourselves. I think we need to look at them in stages, and also some of them, there's lots of changes around trade union representation that if I talk about it now, it will change by the next time it comes into play. So I think it's important the here and now is what's happening in 6th of April. We need to have a look at that. Then let's look at the next changes a little bit further down the line.
Yeah, but the things that we've been talking about today are things you need to be ready for right now. Especially as regards redundancy and statutory sick pay and those kind of changes that are coming in on the 6th of April. Yeah, absolutely. So if you need some personal advice, then obviously Sarah and the team at Franklin's are your first port of call, and make sure you like and subscribe and listen to further episodes of the podcast as we cover more of the aspects of the Employment Rights Act over the coming weeks and months. Thanks very much for your time, Sarah.
Thank you, Chris.